Hello, my name is Alice Min, and today I'll be discussing the historical, social, and political forces that are at play in the Nova Scotia lobster dispute between Mi'kmaq and non-Indigenous commercial fishermen. I'll also be covering the interaction between the Canadian state and Indigenous peoples in Canada, how law plays a role in this, and the importance of reconciliation between the two parties. To give a brief overview of the background, Canada is the number one supplier for lobster worldwide, and the United States is their largest export market. In 2018, there was $1.4 billion worth of lobster harvested from Canada. And although Nova Scotia is one of their smallest provinces with a population of less than 1 million, they're responsible for almost half of this harvest. Just two commercial zones in southwestern Nova Scotia together accounted for 35% of the country's harvest. This leads into the dispute between Mi'kmaq and non-Indigenous commercial fishermen, which gained nationwide attention when arguments started to escalate. This past September, Sipeganegatik First Nation opened their own fishing enterprises in southwestern Nova Scotia and handed out fishing licenses to Mi'kmaq fishermen outside of the regulated lobster fishing season. A lot of conflict arose from this decision, as non-Indigenous commercial fishermen fought back, saying that environmental and conservation laws needed to be followed. This first started with Indigenous lobster traps being cut and ships being vandalized. Then there were reports of non-Indigenous fishermen being arrested for assault and Indigenous lobster ponds being set on fire and burned to the ground. There were threats of blacklisting businesses who bought lobster from Indigenous fishermen and blatant discrimination through the refusal of selling bait, traps, or fuel to any Indigenous peoples. One Mi'kmaq man reported entering a bait shop and being asked if he was Indigenous and then being refused service, which he actually shared was a common occurrence in that region. The non-Indigenous commercial fishermen argue that the governmental laws need to be followed and that conservation laws exist for a reason. Indigenous peoples, however, state the multiple treaty rights and court decisions that make it clear that Mi'kmaq fishermen have the legal right to fish for lobster, even outside the government-appointed fishing season. The earliest treaty mentioned are the Peace and Friendship Treaties that were signed in Halifax between the British Crown and Mi'kmaq Nation in 1760–61. The Mi'kmaq Nation was promised the right to fish and hunt their lands and establish trade, and this also highlights the nation-to-nation relationship between the two parties. Another case, R. v. Sparrow, dates back to 1990 and is the first Supreme Court of Canada, or SCC, case to test Section 35 of the Constitution Act 1982, which recognizes and affirms Aboriginal treaty rights. This judgment concerns Ronald Sparrow, a Musqueam band member who was arrested for fishing with a net that did not comply with governmental regulations. The SEC recognized that the existing Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed, as stated in Section 35 of the Constitution Act 1982. The Musqueam's right to fish had not been extinguished, and the SEC stated that without justification, the government cannot infringe upon these Indigenous rights. This case set a criteria known as the Sparrow Test, which determines when an infringement may be justified, such as in the case of resource conservation. Fast forward to 1999 with R. v. Marshall, where Donald Marshall Jr., a member of the Membertou First Nation in Nova Scotia, was charged for fishing eel without a license. This case made its way up to the SEC, who ruled that the Indigenous nations, including the Mi'kmaq Nation, have treaty rights to hunt, fish, and gather towards earning a moderate livelihood, and these rights flow from the Peace and Friendship Treaties of 1760 and 61. Therefore, the Mi'kmaq fishermen argue that they indeed hold treaty rights to fish for lobster, and that this has been affirmed through legal decisions such as R. v. Marshall. However, non-Indigenous fishermen refer to the SEC's clarification on the Marshall decision, which states that treaty rights are not unlimited and conservation or other important public objectives can be used to justify regulations. So the question then becomes whether it is a serious conservational issue for the Indigenous fishermen to be lobster fishing out of season. The commercial fishing season is from November to May, and the Mi'kmaq fishermen started fishing late September. The commercial fishermen argue that fishing during this time disrupts lobster molting and mating season, which would endanger the population. However, Aaron MacNeil, an associate professor in Dalhousie University's Biology Department and Canada Research Chair in Fisheries Ecology, disputes that by saying the scale of this new commercial fishery is so small that they shouldn't be concerned for the conservation of lobster. When you look at the numbers, the indigenous fishermen have handed out licenses for 11 boats to set 50 traps each, while non-indigenous fishermen are granted licenses for 1,000 boats with 350 traps each. Although the non-indigenous commercial fishing industry has been booming since the 1600s, with British and French colonies depending on lobster trade, the Mi'kmaq have been living in the region for centuries before, and lobster fishing while taking responsible care of the natural resource. Shara Maloney, a political science professor at the University of Cape Breton, shares, "We are so deeply connected to the land, the river, the water, the resources. It's not just how we survive, it becomes who we are." She's also the daughter of former Chief Reginald Maloney, who is known for fighting for Mi'kmaq fishing rights. The traditional land of the Mi'kmaq Nation includes Nova Scotia, New Brunswick, Prince Edward Island, and parts of Newfoundland. It is extremely important to remember the original occupants of the land, and Mi'kmaq people have been fishing and eating lobster, using it for crop fertilizer, and creating jewelry with the shells long before settlers arrived. There is a need to highlight the difference between economic mindsets of settler nations and indigenous nations. Although there is diversity in the economic activities of the different indigenous nations, one commonality is that they depended on a subsistence economy, which was focused on gathering sufficient resources and goods. The communities would share plentiful resources with others and be satisfied with only having what they needed, which showed a respect for the land, resources, and neighboring nations. However, settler nations brought with them a capitalist economy with a mindset of accumulating a surplus of profit. This meant that their goal was to gather as much as possible and focus on accumulating resources and wealth. The settlers also started trade relations with the existing indigenous communities, leading to economic dependency of the indigenous peoples on European trade, which led to other serious issues as European demands changed. Colonialism and the capitalist mindset forever altered the indigenous ways of living, as settlers did not just force nations to move out of their traditional lands, but also impacted their economy. Dr. Chandrakant, a professor at the University of Toronto, says the Mi'kmaq people have known how to manage the land and the resources in lakes for thousands of years, and know more about conservation than settlers do. She believes that the conservation arguments by the non-indigenous fishermen are really issues of implicit bias and systemic racism, and these colonialist ideas that indigenous people do not know how to take care of their traditional land and resources need to be addressed. In all of this, the role of the government is still unclear. The SEC in the Marshall decision made it unclear what they meant by moderate livelihood when they acknowledged indigenous treaty rights to fish, hunt, and gather towards a moderate livelihood. This is one of the underlying issues brought up by both indigenous and non-indigenous fishermen in Nova Scotia, as there are disagreements on what constitutes as moderate livelihood. Patricia Doyle Bedwell, a Mi'kmaq woman and professor at Dalhousie University, takes this a step further and asks why the Mi'kmaq fishermen are even being restricted to a moderate livelihood, when the effects of colonialism has led to serious negative effects like higher rates of poverty in indigenous communities. Additionally, while the peace and friendship treaties highlight the nation-to-nation relationship that is between the British Crown and the indigenous nations, the relationship today does not reflect this. Why are the Mi'kmaq fishermen being asked to stop fishing and wait for the government's response when they have existing treaty rights that have been affirmed through court decisions? Many blame the Department of Fisheries and Oceans Canada for not doing enough to protect Indigenous rights, but also for not taking the lead in conflict resolution between the Indigenous and non-Indigenous fishermen during this time. They are responsible for all Canadian fishery management, but have not showed evidence of being involved in the way that is needed. In conclusion, colonialism has not only had a serious effect on Indigenous communities in the past through cultural genocide and residential schools, but still act as a barrier for Indigenous peoples who try to exercise their existing treaty rights. The government will need to find the appropriate balance between supporting self-governance and helping Indigenous communities to exercise their treaty rights and fight against discrimination. Thank you for listening to my presentation, and I hope that you found this video informative and interesting.